2022. The time is 9 a.m. And Sandy, do you want to lead us in the pledge?
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Thank you. In attendance are Commissioners Brooks and Duncan, and Commissioner Filios should be joining us shortly. Are there any changes to the agenda? None? Okay, great. Opening remarks would be that for our second item, the deliberations, it has now changed from a participation sport to a just an observation. So we won't be taking any public comment, and we'll just be deliberating amongst the three commissioners with potential questions for staff or legal. And we should have an answer this morning. So with that, I'll pull for conflicts of interest. Hi, Chris.
Hi, I'm online. Thank you.
Okay, just polling for conflicts of interest.
No, none for me.
All right, so we'll head on to item 6, which is our signing, ZON 21-0002, KELLNER Zone Change Order of Decision. So anything extraordinary, or we just need a motion?
Just a motion, but as a reminder, there was a tie vote. Commissioner Filios was absent during the deliberations. Chairman Duncan voted in favor. Commissioner Brooks voted against. So there was a tie. That's all.
Okay.
Say that again. I'm sorry,
Well, that's okay. Just as a reminder, this was a tie vote at the deliberations. Commissioner Brooks voted against the request. Chairman Duncan voted in favor, and Commissioner Filios was absent. This is that 50-acre agricultural zone parcel in the Gaza Ranch area.
Okay.
Yep.
All right, is there a motion?
I move that we execute the order of decision.
Second.
Second.
Commissioner Filios?
Aye.
Commissioner Brooks?
Yay.
And Chairman Duncan?
So you don't want to sign the order of decision?
Right.
Pat?
Didn't I vote?
Yeah. Pat, I think maybe go ahead.
Pat?
This is perfect. Yeah, I'm here.
Okay, so if we do not sign the order of decision, does that mean it's in limbo, or what happens?
That's a real interesting question. I would, basically, if that's the case, there just would not be any written order. I would encourage the board to vote to authorize signing, reflecting that 1-1 tie and the reasoning behind each commissioner's vote, because a tie vote is a denial under Idaho case law, and so this would put that decision in writing for, so that the applicants could have their due process to challenge the decision and as they see fit.
Okay, thank you. Aye.
Yep.
So motion carries, and do you have the paperwork? Thank you. Chris, can we use your stamp?
Yep.
All right. So then, Pat, when we're filling out the yay and nay, it's not the yay and nay for the signing, it's the yay and nay for the decision?
That is correct.
Okay. There you go.
Wow. Okay.
All right, we are on to item 7, and this is our deliberations. CUP 22-0004, INGLE, AT&T, and SMARTLINK. So, Vlad, do you want to lead us off, or we just want to start right in?
Yeah, why don't we just start right in?
Okay. Do you need
Do you have some things to say, Vlad?
No, I just want to remind the board and the public that the board held a public hearing on this matter last Thursday, and a motion was made at the end of the public hearing to postpone with the deliberations to today's date.
Okay.
So do we need a motion then to actually enter into deliberations, or are we okay to just proceed?
We're okay to just proceed. We entered into deliberations pending the rebuttal, which we received yesterday.
That's correct.
All right. So, Chris, do you want to start?
Yeah, I'll start. Okay, so by the way, thank you everyone for letting me participate remotely. It's because I had major surgery several weeks ago, so thanks for indulging me. Okay, so, it's interesting. We've got a few different pieces of input here. Obviously, we have the residents, we have the appellant, and of course, we have the hearing examiner's conclusion, and the hearing examiner did indicate that it should be denied, but at the same time offered a series of conditions that should be incorporated should we decide to proceed. And I took some notes as we went through the deliberation, and obviously there were different concerns, health, which shouldn't be forgotten, potential for lightning strikes, was it an exhaustive search for the right location, possible visual intrusion. And so I'm trying to address each and every one of these. I don't know if I can do that comprehensively, but certainly the comments from the residents were compelling. How many of those were actually substantiated, I don't know. There was a gentleman who spoke at the very end. I think he came in at the end, as I recall, who had a background in EMI and this type of radiation, and touched on the issue of the increased cell use. And I should point out that Idaho has one of the highest percentages of landline having diminished and cell use in the country. So that's something to bear in mind. So if I look at the comments from, for example, the residents, one of the concerns was that we have to consider health. But what it's interesting is that there's a quote that the HE included in her conclusion that says, as it relates to the potential health risks, the Telecommunications Act of 1996 prohibits state and local regulation of such facilities to deny an application on the basis of environmental effects of radio frequency emissions to the extent such facilities comply with FCC regulations, and there's no reason to believe that this does not. There was compelling evidence by a woman who referenced the situation with her twins, and it's very concerning to me, but I can't conclude from that the presence of this tower is necessarily posing a health risk to the children. The other issue, I guess, is the access road. And once again, hearkening back to the hearing examiner who did deny this, indicated that the situation as regards the road has been around for years, has not been addressed, and by the way, is not being addressed, at least not by the relevant agency, which in this case is Eastside Highway District, with regard to this application. Okay. Visual impairment, let's look at that. The state of Idaho does not protect view sheds. If you want a view, that has to be, it's called a view easement, and typically that's negotiated between and among neighbors. Back to the hearing examiner's conclusion again, promote the use of fire prevention measures and whatnot, okay, and promote the protection of view sheds. I take issue with that for the reasons I just gave, especially with regard to the view sheds. minimizing the negative impact on citizens. Okay, the hearing examiner does conclude, and I believe the rebuttal from the appellant addresses this, that it really doesn't agree with the comprehensive plan. And there were concerns also expressed by the hearing examiner that perhaps there was not an exhaustive search for an alternative location. I'm not convinced that I agree with that. I think when someone approaches it, whether it be Verizon, AT&T, T-Mobile, it doesn't matter. I believe their search leads them to conclude where they're going to get the greatest efficiencies, and by that I mean the greatest amount of coverage for the least amount of expense. And I think they have already done that, and I think that was also expressed in the rebuttal. If we go on, once again, I think the rebuttal addresses many of the concerns that were expressed by the hearing examiner, and for that matter, the appellants as well. Someone also indicated, I meant the residents. One of the residents indicated there should be a surety bond of $32 billion. Presumably that comes from the total valuation in the area. That's fine. I don't know how relevant that is. Somebody else even argued that values in the area would be diminished. I think the appellant addressed that by citing different urban areas around the country. Boston comes to mind, where the values actually increase with the proximity to the cell towers. And once again, this is an area that is highly, highly dependent on adequate cell coverage, and especially as regards health and safety and the ability to more accurately pinpoint 911 locations. Clearly, the hearing examiner went on to say that if, in fact, we choose to approve, she stipulated a series of conditions. Those are indicated as sections 8.01 in her conclusion through 8.15. And so it's difficult for me at this point to necessarily side with the appellants, with the residents, however compelling their arguments are. Because again, from the various perspectives that I indicated, whether it be health, whether it be the choice of location, whether it be the proximity to the tower, the road, and once again, highlighting the fact that none of the responding agencies had any serious issues. If AT&T is forced to seek an alternative location, what's to say that the residents don't rise up once again? This society, and Idaho in particular, is highly, highly dependent on adequate cell phone coverage. And so, from my perspective, I would side with the appellant and necessarily include the conditions for approval that the HE, the hearing examiner, recommends, and once again, they are 8.01 in her conclusion through 8.15. So that concludes my points. Thank you.
All right.
I have a question. Chris, could you read what those conditions were?
I have them already.
That's sure. It might take. Okay, sure. I'd be happy to. I'll try to summarize each one, Bill.
Okay.
8.01. The conditions shall run with the land and remain valid upon a change of ownership until such a time as the permit expires, is revoked, relinquished, etc. It's not transferable, so I'll just leave that one at that. 8.02, changes in the condition in terms of this order decision shall not be undertaken by the applicant or future assigns having an interest in the property until the community development director has reviewed all these changes. 8.03, the project shall conform to the narrative and project plan that were submitted, labeled exhibits, et cetera, minor modifications can be granted as approved by the director. 8.04, the applicant or future owners shall, pursuant to a later section of the Kootenai County Code, obtain a site disturbance permit prior to the beginning of any land disturbance activity associated with the tower. 8.05, lighting of the tower shall be prohibited unless found to be necessary in the future by the FAA. In the event that the lighting is installed in the future, it shall be downward directed and shielded to prevent illumination no greater than 0.2 foot candles. 8.06, applicant shall comply with the following requirements of Kootenai Fire and Rescue District for ingress and egress, and the address will be posted on the roadway. 8.07, they'll comply with the following requirements of the East Side Highway District per the associated exhibit, and obtain an approach permit. 8.08, applicant shall comply with the following requirements by the Idaho Transportation Department. Lighting and marking is not required by the state of Idaho. However, if it were to be accomplished on a voluntary basis, applicant shall follow the FAA installation guidelines, outlined in the FAA advisory circular, and the numbers cited. 8.09, applicant shall comply with the following requirements of Kootenai County Building Division per Exhibit PA-4. All the construction code requirements, I guess that basically have to be compliant with our building codes. And all construction documents will be required to be prepared by an Idaho licensed design professional. 8.10, prior to the issuance of any development permits for the construction of the WCF, the applicant shall provide to the community development staff a duly recorded perpetual right of entry and or land lease agreement from the underlying property owner. 8.11, applicant shall paint the wireless communication facility in a neutral color to blend in with the surrounding natural environment. 8.12, unless otherwise approved, if the proposed construction or use authorized by this CUP has not been established within 2 years from the date of the signing of the order of decision, this approval shall expire. 8.13, order of decision approving a conditional use permit application shall be recorded at the owner's expense in accordance with the necessary subsection of the Kootenai County Land Use and Development Code. 8.14, applicant shall undertake a professional forest management plan for the entire parcel prior to the issuance of any development permits that will include details of trees to be removed, defensible space to be provided, and means and methods to be followed for annual maintenance and adherence to the forest management plan. 8.15, applicant shall immediately restore any damage done to Potlatch Hill Road during construction such that the condition of the road is no worse than it is on the date that any permits are issued by the Kootenai County Building Division, and will continue to the costs incurred by other property owners on Potlatch Hill Road of maintaining and managing the road over the time the WCF is operational on this property. And that concludes the recommended conditions should we choose to approve. There you go.
Vlad?
And Chairman Duncan, Commissioners, Pat Braden, for the record.
Yes, Pat?
Yeah, I just wanted to mention that the last two conditions that Commissioner Filios read into the record are additional conditions that the HE included in her recommendation that were not originally recommended for approval by staff. That would be conditions 8.01 through 8.13. And I do also note for the record that the applicant did object to those final two conditions. So I don't, have an opinion as to whether those two should be included or not. I don't know if staff does. But I just mentioned that for, so those two can be discussed specifically.
Okay, thank you.
And which two of those, Pat, would that be 14 and 15?
That is correct.
Okay, thank you.
All right, Vlad?
Commissioners, if I may, I'd like to provide clarification to each of the proposed conditions of approval by the hearing examiner, and why staff believes that these conditions are problematic and are likely not enforceable. Is that okay if I provide information in regard to each one of those?
On each and every one?
No, just the two.
Last two.
Okay.
Pat, is that all right for Vlad to do that?
Yes.
Okay.
And if staff's position is inaccurate or is not legally defensible, I'd like to have Mr. Braden provide further analysis in that regard. With respect to the forest management plan, in reading the rebuttal submitted by the applicant, the board needs to understand that that AT&T is leasing a portion of the property. They do not own this property, nor do they have the legal rights to traverse or utilize it in the manner as they choose outside of the leasing area. So if they were to be required to provide a forest management plan, that would be outside of the leased area for the cell tower and the compound. And as stated in the attorney's rebuttal, if they were required to remove a number of trees to mitigate the potential risk of fire, a majority of that site would have to be denuded. And they did provide a visual graph of what portion of the property would remain treed. Clearly, a majority of that site would be denuded, and all of that would be outside of the leased area by AT&T. That's the first issue. The second issue on condition 8.15, I think it's clearly understood by the applicant that while they're constructing on site, if there is any physical impairment to the adjoining public road, that would have to be restored in compliance with East Side Highway District, because said road is a public road under the jurisdiction of Highway District. Therefore, staff, and Mr. Braden can jump in, cannot enforce, or the board should not require them to pitch in into any sort of annual financial commitment, because this is not a private road. There's no private road development agreement that would force them to make a financial commitment to. This is a public road that each and every taxpayer in Kootenai County pays to maintain, supposedly. And that's staff's observation. If Mr. Braden believes that that's an inaccurate assessment, I'd like to have him provide further clarification in that regard.
Pat Braden. The only comment I would have, and I agree 100% with Mr. Finkel's analysis, is that I don't think it would be unreasonable to, have them, repair any damage that may be caused to the road during the construction process. But I agree with Mr. Finkel. I think the rest of that is the annual maintenance is problematic given the nature of the road as a public road maintained by East Side Highway District.
Understood.
All right. Bill?
Excuse me, I should have done that before. I see there are basically three different important aspects to this deliberation for me. One is the likelihood of fire that is lightning being attracted to the surrounding area. And so what I did was I contacted a couple of people I know, one an electrical engineer, PhD, and asked him, and another fellow who was in the what we call the wire telephone business, not cell telephone, and both of them said no. There's no additional. It doesn't attract lightning. It doesn't attract lightning. Lightning does hit things like the highest object, which this sounds like it will be on the skyline, but if it's adequately grounded with a lightning rod, it doesn't cause any damage to anyone. But the fire danger up there in Armstrong Park in that area does concern me greatly, and I think we ought to get busy with East Side Highway to make that a much safer area, because fires come from a lot of other things other than lightning strikes. And if the fire is as great a danger as the people portray it to be up there, then something should be done quickly. It's not a whenever. But as to whether the cell tower will make that fire danger worse, I do not believe it will. There's a lot of anecdotal evidence that it will. And one of the things that as a commissioner, I reject anecdotal evidence. When people have, we did it on the wave study. I mean, there's a lot of people with, I know somebody who, or everybody knows that, and that's not evidence. And that also goes for the health effects of 5G. If you look at the exposures, 1G, 2.5G, 3G, 4G, they all are in many ways worse than 5G. And I've seen no evidence that cell towers make people sick or cause birth defects or any of these other anecdotal stories that I've heard. It's just not there. As to the aesthetics and a big pole being there, I don't like that. It kind of wrecks the view, doesn't it? I mean, if you're used to no pole, it kind of hurts the view. But I did look at the studies, that is the photographs that AT&T took, and I think that unfortunately it's one of those things you get used to if you want cell coverage, and everybody around here, almost everybody, depends on cell coverage. So I'm going to go against the hearing examiner's recommendation myself and approve this request.
Okay. All right. I look at CUPs a little bit different than I do applications by right or applications that just have to go through a process. So this being a conditional use permit, meaning there's conditions, it's not just automatically allowed. I would agree with the hearing examiner about it does not adequately address site constraints or hazards and adequately mitigate any negative environmental, social, and economic impacts. When you're looking at a neighborhood and people who come and testify, I listen to what their reasons are, and if there aren't mitigating conditions, then I take that into consideration. For this particular one, I think that the citizens, although we can't take health into consideration because the law does not allow that. And if we don't like that, we have to change the law. The other thing that the law does not, well, sorry folks, I'm getting a headache, so things are not flowing like they usually do. I have serious concerns with this application. I think there was more due diligence that could have been done in regard to an exhaustive search. We didn't hear any testimony that said that additional coverage was desperately needed. I do understand about AT&T trying to, provide a better service to their customers, but the spaces in that area, I mean, there are identified locations that could use additional service, but they weren't here to testify. And as a matter of fact, we had Kootenai Sheriff testify that they are not in favor of this application. So at this point, I think that some additional, in order for me to approve it, I would like AT&T to better explain and further explain about how this is the only location that can be used. And so I can't support this application as it is. So With that, what conditions are you and Chris wanting
Well,
to?
my motion would be that we approve it with the inclusion of the conditions of the hearing examiner, except for the last two.
Okay. All right. And then Pat, go ahead.
Yeah, I know you wanted to ask Pat a question, so go ahead. But if you're ready for a motion, I can make it.
Yeah. I did have a question for Pat. Since this is going against the hearing examiner recommendation, does that automatically put us into another public hearing?
On a conditional use permit, it does not. That provision only applies to zone changes, ordinance amendments, or comprehensive plan amendments.
Okay.
So this would be the final decision.
Okay.
But if I may add, Commissioners, Mr. Braden, it's true that the public has the right to request a reconsideration within 14 days of the signing of this decision. I want to make it clear to the public that they're welcome to submit a reconsideration request.
To whom?
By final, I mean, final subject to those processes that are in our code and are required under state law.
Okay.
It would be
Pat, go ahead, Vlad.
the reconsideration will be submitted to Kootenai County Community Development to have the board reconsider their final decision on this matter. Staff would then initiate a 30-day public comment period to notify the adjoining property owners of a new public hearing set for the reconsideration, and then the board would hear it again. As you may know, once a reconsideration request is formally submitted, we would advise you on that at the next available meeting, just to give you heads up that a reconsideration request is coming forward.
All right. And then my final question, I hope. If 14 is being removed, how about requiring the property owner to do something like Fire Smart? So I understand how problematic it is for a forest management plan, but what about Fire Smart or something to that? Because that doesn't include removing trees. That is a brush issue.
What I would recommend is you direct staff to write a condition of approval that the applicant must initiate a fire smart review with the fire district with jurisdiction and have them advise them on the necessary steps that need to be taken for preventative measures, and have that be reviewed and approved prior to issuance of any development permits on site.
Okay.
I think it's a good idea.
Okay. So Chris, did you follow that?
Yeah, I did. I've got a final question.
Mm-hmm.
There are terms that apply to reconsideration, and I'm specifically referring to specific changes or new information that comes up, and I would ask Pat to opine on that, because it's not a simple revisit of what we've just been through.
Okay, let me actually pull up the provision of county code that applies, and it actually parrots the language in the Local Land Use Planning Act regarding requests for reconsideration, so that everybody is on the same page with that. Okay, well, I'm going to have to open up two windows, so bear with me for just a minute.
Okay.
Sure.
Because our county code actually references the state law, and so I want to get to the state law real quick. Okay. The request for reconsideration is limited to argument that the allegation that the Board of County Commissioners failed to identify the nature of compliance or non-compliance with express approval standards, or that the county commissioners allegedly failed to explain compliance or non-compliance with relevant decision criteria. And those two items are the potential grounds for invalidation of an approved permit or site-specific authorization. And that is, it would have to be filed with community development within 14 days after the signing of the written order of decision. And besides that, the process is, as Mr. Finkel indicated in his comments earlier.
All right, thank you.
Good. Thank you.
All right, we ready for a motion?
Sure. Shall I make it?
Sure.
Okay. Okay, so then with respect to conditional use permit 22-0004, I move that we approve the conditional use permit by the appellant, which is AT&T, property owner is INGLE, with to include the hearing examiner's terms for approval, should we choose to do so, indicated in her analysis, which are specifically items 8.01 through 8.03, specifically excluding 8.14 and 8.15 to be replaced by... Yes?
I think you said 8.03 as opposed to 8.13.
Oh, forgive me. Okay, so thank you, 8.01 through 8.13, specifically excluding items 8.14 and 8.15 to be replaced with two other items, the first of which is for the appellant to repair any road damage as a result of the construction of the WCF, and a second item, which is to initiate a fire retardant or fire avoidance system or mitigation through FireSmart or some equivalent organization for the area specifically impacted by the construction of the WCF, and that is the end of my motion.
I second the motion.
Commissioner Filios,
Aye.
Bill Brooks,
Aye.
Chairman Duncan.
Nay. All right, motion passes and CUP 22-0004 has been approved. And with that, it is 9:38 a.m. Meeting adjourned.